Do not kid yourself. Just because a partisan Justice Department objects to a submittal does not make it and does not necessarily mean they are right. The Supreme Court has said on occasion that they are wrong, nor does it mean there has been any discrimination. I urge you members to support updating the Voting Rights Act for the 21st century with this amendment, and I reserve the balance of my time.
I reserves the balance of his time. Gentleman from Wisconsin.
Chairman, I rise in opposition to the amendment.
Gentleman is recognized for 20 minutes.
Chairman, I yield myself such time as I may consume.
Gentleman is recognized.
Mr. Chairman, this amendment guts the Voting Rights Act, and let's make no bones about it. It does so by altering its coverage formula to cover only those jurisdictions in which voter registration and turnout fell below 50% in 2004, 2000, and 1996 presidential elections. Based on the Census Bureau current population survey, there is not a single state except Hawaii with voter registration and turnout below the 50% required by this amendment. That means that only the state of Hawaii in its entirety would be covered, along with random, scattershot jurisdictions across the country that do not have the century-long history of discrimination that the covered states do, and which the Supreme Court requires for the application of the pre-clearance and federal observer provisions contained in the VRA. The amendment not only guts the bill, but turns the Voting Rights Act into a farce. To give you a sense of the absurdity of this amendment, let's take the example of Montana. In Montana, the amendment would only cover